Okay, I'll turn the attendance on for the 3 of you that are here. So silly. Okay. All right, so we are officially down to registered of 6. 2 people have dropped the class. So we're down to 6. I'm sorry, we went from 6 to 4, I'm sorry. And eventually we'll have all 4 of you, I think, at some point. Maybe not, I don't know. Let's see. Were you able to watch, Lindsay, the class from last week on the video?
A little bit of it.
Okay, and Audrey, were you able to get the video from last week?
Yes.
Okay, very good.
Yeah, I tried to stream it the day of, but was having internet problems.
Okay. Okay, all right. Are there any questions? Anything in your minds? No? Okay. We are moving on to the second major topic of the class. At most law schools, ConLaw is divided into 2 units, ConLaw 1 and ConLaw 2. And ConLaw 1 is generally viewed as the structure cases, enumerated powers and federalism and things of that nature. ConLaw 2, in contrast, is often called the rights section. This is the sort of sexier stuff, right? We're talking about the 14th Amendment, we talk about equal protection, we talk about due process, we talk about segregation, we talk about abortion, we talk about gay rights, we talk about free speech and these sorts of things. And a lot of law schools draw the sharp divide between the structural provisions of the Constitution and the sort of rights provisions. I don't draw that distinction. I think the reason why these structural provisions is to protect freedom and protect liberty. I gave you an example the first week of class. The year 1790, the Bill of Rights has not yet been ratified. Can Congress pass a law banning newspapers? And the answer is no. We don't need a First Amendment. Congress has no power to prohibit the press at all. No enumerated power. So we have that sort of dichotomy, but we will be moving on to the second half, which is almost all about rights. And we'll probably be spending the next, 10 classes or so, maybe 15 classes on the 14th Amendment. It's not long, right? You have it in your book. You can read it in a couple minutes, but there's a lot of stuff in there. And to understand the 14th Amendment, we have to trace the history of what came before the 14th Amendment. And this history is generally not taught in school, so I won't presume that you know it. But we have to walk through this history step by step. So I'm actually going a little bit out of order. I'm going to start with the history before Dred Scott, and then we will do Dred Scott when we get to it, okay? All right, any questions?
Just real quick.
Please.
In your lecture video, you were talking about how the school was possibly going to go to 2 sections of.
No, that didn't happen.
Okay, so it's.
We watched from last year, my lecture. My recommendation was to have 3 units of ConLaw 1 and 3 units of ConLaw 2. So 6 total. I didn't get voted. I think they get voted up. So instead, they basically left ConLaw as it is and added First Amendment as a mandatory class, which is 2 hours. Okay. Now, I'll tell you, you don't need 2 hours to teach First Amendment. You could probably do it in 1, but you can't do really 5 in 1. So as a result, we have a lot of coverage on First Amendment, and still have to race through everything else. The one advantage is on your syllabus, I cut off First Amendment, so that lets me spread things out a little bit more. So slow things a little bit down more at the end of the year. So that's the only difference. Unfortunately, I wish we had the 3 and 3,
I was
but
just wondering what it meant, since our class didn't get the split ConLaw. I just didn't know if they were.
No one did. It was too complicated to do. It's easier to add a class than to revise an existing one, if that makes sense. Like, for example, everyone took Civ Pro 1 and now there's a Civ Pro 2. I don't know if that affects you.
Wait, they just.
For the incoming 1Ls, there's now a Civ Pro 2.
How do they split it?
So instead of 4 hours, it's 3 and 3.
Oh, okay. Wow. Okay.
And a lot of other mandatory classes like Crim Pro and things like that. Okay. So let's start with a few provisions of the Constitution. And the first thing that I want to flash back to is the very first day of class is this language. The Constitution was enacted against the backdrop of slavery. But the framers never actually used the word slaves. And that was quite deliberate. The bulk of the people who were at the Constitutional Convention recognized that this was a serious issue that would likely fracture and divide the nation. Indeed, it did. And they were so hopeful that this issue would maybe resolve itself at some point in the future that they sort of left the issue under the rug and said, we'll deal with it later. So, for example, we have Article 1, Section 9, right, which concerned the fugitive slave trade, right, the literal importation of slaves from foreign countries. And what it basically says is that Congress cannot interfere with the slave trade until the year 1808, 20 years after ratification. And the hope, the sincere hope, was in 20 years, hopefully get our shit figured out, right? We'll figure something out, but we're not going to do this now. In fact, there's actually a clause in Article 5 which says you can't even amend the Constitution to get rid of the slave trade before this year, right? Query, can you actually have an amendment that's unconstitutional? Right? What if they amended the Constitution? It would have an effect. But this was a very important reflection of the fact. You also have the 3/5 clause, which reduced the representation of other persons, but again, it didn't use the word slaves. Okay. Then we studied in Prigg, you recall, Prigg v. Pennsylvania, the Fugitive Slave Clause. That appears in Article 4. Right? And it says that no person held to service or labor in one state escaping to the other, but shall be discharged upon a claim. In other words, slave runs away from Maryland to Pennsylvania. Pennsylvania is then required to return the slave back to the slave state. Congress went a step further and enacted the Fugitive Slave Act, which regulated how slave catchers could go from one state to the other. Some people, like Chief Justice Chase, argue that the Fugitive Slave Act was unconstitutional because Congress lacked the enumerated power to enact this law. Justice Story in Prigg disagreed. He said that the Fugitive Slave Clause and the Necessary and Proper Clause give Congress the necessary powers to regulate the interaction between the states. Okay? But there's another part of Article 4 that we haven't talked much about, but we're going to talk a lot about today, which is the Privileges and Immunities Clause. Again, it's in the same part of the Constitution, Article 4, Section 2, as the Slave Clause. It's like basically 2 paragraphs up. And these were all provisions that concern the relations between states. Right? Article 4 says, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. Okay, so the phrasing is a little bit weird, but at the most basic level, this means that, for example, Texas, right, cannot discriminate against an Oklahoma resident. Whatever rights Texas gives to its own citizens, Texas must afford those same rights to an Oklahoma citizen who's traveling. Right? This would prevent, of course, a person going from one state to the next from being discriminated against. But it doesn't affect only persons. It says citizens. Right? So these are rights limited to citizens. Is everyone with me? So first off, what are these privileges and immunities? This is a word, or actually a phrase, privileges and immunities, that doesn't have much weight. I promise you, if you actually look at your diploma from college, just go back and look when you get home, it probably has the words privileges and immunities on it. Probably never even noticed. Mine does, right? But this phrase, privileges and immunities, refer to certain rights And not just like, any rights. Rights were deemed very important or fundamental. And the leading opinion that we look to interpret this provision is not actually a Supreme Court decision. It's a decision that was authored in a circuit court case, a lower court case, called Corfield versus Coryell, Corfield versus Coryell, Corryell. I was going over the proofs of this book. You only notice in one spot we wrote cornfield. Did you notice that? No, I did. I caught that this morning. I wanted to murder myself. We wrote Cornfield versus Coryell. Randy would have killed me if that made it to print. We're still going through the final rounds. I've read this book so many times, finding all these errors, they just kill me. He would have murdered me. Corfield versus Coryell. And the opinion is written by Justice Bushrod Washington, who was the nephew of George Washington. Kind of cool. Your uncle's the president. You're on the Supreme Court. And this case was one of the earliest judicial decisions interpreting what these rights were. And Justice Washington listed a number of different kinds of privileges and immunities. For example, protection from the government, right? The government to protect you. He wrote the right to acquire and possess property of every kind, right? You have the right to acquire property and possess it. You also have the right to obtain happiness and safety. Now, these weren't particularly detailed or specific definitions, but Washington was trying to explain at a high level what these sort of rights were. Now, why was this provision so important in the early years of the Republic? The controversy actually arose in the southern states. So you had ships with black sailors. They were freemen, right? They were citizens of perhaps Massachusetts, or maybe they were citizens of Pennsylvania, or maybe citizens of any number of northern states. And then what happens when these free black sailors docked in southern ports? At that time, they were often arrested. They were harassed. They maybe were thrown into bondage, right? Slavery. And a number of abolitionists, Horace Mann and others, argued that the states, the southern states, couldn't treat these free citizens in that fashion. The argument was, whatever rights South Carolina gives to its own citizens, whatever privileges and immunities South Carolina gives to its own citizens, the same privileges and immunities had to be given to the Massachusetts citizen or the Pennsylvania citizen. In other words, they couldn't throw them into bondage. They couldn't harass them and arrest them. They had to treat their own citizens the same way they treat foreign citizens. The southern states said, absolutely not. We will treat these people the same way we treat our own slaves. They rejected the notion that these people were citizens. Right? So what do? Where Massachusetts says this person is a citizen, and South Carolina says this person is not a citizen. And notice the language. It doesn't say citizens of the United States, right? It's not talking about national citizenship. It says citizens in the several states. That is, you're a citizen of Pennsylvania, for example, or a citizen of Massachusetts. Right? And if, in fact, they were privileges and, they were citizens, then they were entitled to privileges and immunities. Right? Now, this clause plays a central feature in Dred Scott. We'll go through Dred Scott in a few minutes, but Chief Justice Taney goes out of his way to highlight this clause. He says there are some privileges and immunities that are very important. For example, the right of free speech, the right to bear arms. And he says there's no way that these African Americans can get these rights. No way. He effectively says if they in fact were citizens, then they would get these rights, but they can't get these rights because they don't have them now. And we know that's wrong. And if they were having these rights, we wouldn't have a union. The southern states would have never joined the Republic if they knew that their slaves could now have right to have guns, right? That their slaves would now have right to free speech. And it was Taney's major move in Dred Scott was to create this distinction between state citizenship and national citizenship, right? Tawney, he does this very, 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 very deliberately. Explains that even if the state of Massachusetts says you're a citizen, that's basically a worthless piece of paper. It doesn't matter. What matters is you'll never be a citizen of the United States, and therefore you cannot get these privileges and immunities of citizenship. So the Privileges and Immunities Clause, which doesn't get a lot of attention today, played a central role in Dred Scott itself. Okay. Everyone with me with just understand this background, right? Okay. All right, so now we are caught up to date with Dred Scott v. Sanford. And I think this is referenced in the book, but the name in the case is Sandford with a D, Sandford, S-A-N-D-F-O-R-D. S-A-N-D-F-O-R-D. The guy's name was actually Sanford, S-A-N-F. At some point, an error was put into the transcript of the report, the proceedings of the court. Oh, by the way, if anyone saw, has anyone been to St. Louis? Did anyone see the footage of the parade for the St. Louis Blues the other day? Okay, they won the Stanley Cup. If you ever go to St. Louis, there's the arch, right? The huge metal arch. Across the street, there's a courthouse. That is the Dred Scott courthouse. That was actually where Dred Scott was tried. And if you go to the backside of the court near the arch, there's actually a statue of Dred Scott and his wife Harriet. And I think the street's called Dred Scott Way or Dred Scott Place or something. The actual courtroom has since been destroyed, but they recreated the courtroom to resemble what it looked like in the 1860s. So if you ever go to St. Louis, I encourage you. They have a little exhibit on the first floor. It's very nice. I mean, I thought it was a well done exhibit. Okay, just saying, St. Louis is easy to get to. Okay. All right. So Lindsay, let's just start with the facts of Dred Scott. There's a lot going on here in Dred Scott. I mean, there's so many moving parts to this case.
So Dred Scott was a slave in Missouri.
Good.
Whose owner was a surgeon in the Army.
Very good.
And he traveled and ended up in Port Snelling.
Where is that?
Which is now, it was federal territory at the time. It's present-day Illinois.
No, Fort Snelling is present-day Minneapolis.
Minneapolis.
Yeah, if you ever go to the Minneapolis airport, I've never been, unfortunately. I keep not having time, but Fort Snelling is actually like a mile from Minneapolis-St. Paul Airport. So if you're ever in Minneapolis, take a detour. I've never had time, unfortunately. Okay, so the surgeon took Scott and his family, right, and his wife Harriet, right? Yes.
Federal territory.
To federal territory. It was Wisconsin territory, right? Okay, let me just pause you there for a minute, Lindsay, okay? What's the significance of the fact that this was federal territory? Some years earlier, Congress had enacted the Missouri Compromise, right? What's the Missouri Compromise? The Missouri Compromise was, as the name suggests, a compromise, a deal, that all new states admitted to the Union would either be slave or free, depending where they were located. That if there was a line or a state north of what's the 36th parallel, I can never say that. Basically, north of Missouri, the state would then be a free state, free soil, as it was called. And if it was below the 36th parallel, the state would be a slave state. Why was that significant? Today we think of sectional conflicts in terms of like Republicans versus Democrats, right? Which somewhat maps north-south, but not exactly. In the early 1800s, the conflicts were not necessarily north-south, it was slave-free, right? That was the dividing line of our polity. Why? Because if there was a free state, the members of Congress elected would probably be opponents of slavery. The senators selected would be opponents of slavery. If there was a southern state that was slave, the people sent to Congress would be pro-slavery. So all the debates in Congress about slavery turned on how many free states there were and how many slave states. If there were too many slave states, they'd have more representation in Congress. If they have too many free states, they would have more representation in Congress. That also affects, of course, the presidency, right? The president is chosen by the Electoral College, which means you count up the number of representatives and senators in each state. If the slave states had more electoral votes, then most of the presidents elected would be pro-slavery. In fact, In the early decades of the Republic, almost all the presidents were Southerners. Right? John Adams and John Quincy Adams were exceptions. Almost all the presidents were Southerners. And guess what? Most of the justices appointed were also Southerners. Were also going to be pro-slavery. Indeed, Chief Justice Taney. His relation with slaves is somewhat mixed. He apparently had a change of heart later in life, but he was generally supportive of the institution. But his own slaves, I think he emancipated. But the result is you have more states. So the Missouri Compromise was a deal. You keep slavery in the southern states, you make abolition, no slavery in the northern states. But what about the territories, right? Before a state was admitted, the federal government basically held that land as a territory. It was more or less governed by the federal government. It wasn't a state, it wasn't federal. It wasn't a state, it was a weird in-between. So Congress has what's called the Property Clause, which is a provision of the Constitution you've never heard of. Right? But it says that the Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or the property belonging to the United States. Okay? This clause was generally understood to give Congress the power to set rules in the federal territories, which would include, right, whether it's slave or free soil. Now, long before Dred Scott was decided, people were already starting to worry about these territories. Because what would happen if Congress declared a territory to be free soil and there were slaves in that territory? At that point, the slave would then be presumably emancipated, which would presumably deprive the owner of some species of property, the chattel slave. So in the early 19th century, members of Congress started developing reports which suggested that it would violate the Fifth Amendment to declare a free soil territory. Why? Because the law would deprive people of their property without due process of law. Now, we haven't really talked about the Fifth Amendment, but we started a little bit now. When I say process, you think of like a trial, right? A judge, a jury. But the argument here was a little bit different. The notion was that no matter what process you were given, the law was inherently unfair. That the government can't deprive you of that property at all, right? It's just you have a right to this, and the government can't take it away from you. So many Southern members of Congress actually argued that the prohibition on slavery in the free territories violated the Fifth Amendment. Roger Taney did not make this up. People think this. Taney didn't make it up. He got it from other people who were long before him. Right? So people were already aware of this problem that if you brought a slave to a free territory, it might violate the Fifth Amendment. But what happens if you brought your slave to a free state? Illinois, for example, which was a free state, it's where Lincoln was from. There was also concern of two ways, right? One, if you brought a slave to a free state, maybe the slave could then go to a court there and get emancipated. So the Southerners actually might have argued that you had a right to keep a slave without being deprived of due process. But wait a minute. The Fifth Amendment doesn't control the states, it only controls Congress. So this is where the Missouri Compromise comes in, right? The Missouri Compromise was dictating that new states would be free soil, and that was a federal law. There was a serious debate. Could the nation live with divided slavery laws, right? And yes, in the South, no, in the North, where people move around. The Northerners were afraid that the courts would actually hold that slavery had to exist in all 50 states, right? That you couldn't actually have a non-slave state because people bring their slaves with them and they can't be deprived of this. I'm only briefly sketching this history, but there was so much going on behind the scenes in this case that help explain why Taney did what he did. Right? The actual dispute in Dred Scott was fairly narrow, but Taney reached all the other issues to resolve the sort of questions I'm raising here. Okay, so questions so far? All right, Chelsea. I think, you want to continue giving me the facts of how the conflict in Dred Scott arose, please?
Yes. So then the owner remarried to a woman, and they sent the woman Scott, and Scott married a woman named Harriet, and they moved back to St. Louis.
Good, yeah, Missouri, good.
And
By the way, where were they kids, right?
yes,
Where were the kids born?
in Wisconsin.
Yeah, one was born in Free Territory, the other was born in the river. Can you imagine giving birth in a riverboat? Just can you imagine that? I can't even fathom that. You see these videos of people giving birth like in Chick-fil-A and stuff, but you know, this is like a riverboat. All right, go on, Chelsea. I'm sorry to interrupt.
And when the owner died, he left Dred Scott to the wife Irene.
Good.
And Scott wanted to buy the freedom for his family, but Irene refused. And
Yeah.
so he took it to Missouri State Court and argued that because he and his family had lived in a free territory where slavery was banned, that they were legally.
So who was Sanford?
Her brother.
Okay, her brother. Now, I only learned this last year when I went to the courthouse. Irene remarried. Why wasn't the husband the person who was bringing this, who was the person who was actually litigating this lawsuit?
Because he was
He was an abolitionist. Good.
Yeah.
He was an abolitionist. Right, so basically Irene marries an abolitionist, and he's like, I don't do any of this crap. So basically she hands Scott off to the brother-in-law, her brother. Right, Sanford lived, where did he live, Sanford? It's actually important.
I don't recall.
Audrey, where did the brother live?
Is it St. Louis?
No,
Iowa.
no. New York. Why is that important, New York?
Oh, because they're diversity situations.
Bingo. All right, so I cut Chelsea off, I'm sorry. Let me go back to the point, right? So initially, Scott sues for his emancipation in state court. Right, this was the St. Louis courthouse that I visited, I think a few months ago, whenever it was. Under Missouri law at the time, a slave who traveled to a free state would actually be emancipated by virtue of his travels. Right, that was a law, but that was a matter of state law. And the Missouri Supreme Court actually reversed itself and got rid of that opinion. If I remember correctly, it was like either 2 members in the court or 3 members. It was a very small court that decided that issue. And I think that decision may have been rendered in the capital, which is Jefferson City, I think. Maybe it was Columbia. I can't remember where it was. But anyway, the court ruled that under state law now that Scott would not be emancipated. Scott did not appeal that decision to the U.S. Supreme Court. Instead, he got creative, and he sued again in federal court. Now, at the time, there was no federal question jurisdiction, right? Indeed, there's no federal question here. He was basically suing to assert that as a matter of law in diversity, that he should be emancipated. Now, Audrey, you know this from Erie, right? When you sue in diversity, what law does the court apply?
Federal law.
Federal law?
Well, it depends on the.
What does Erie
state
say?
law.
Oh, and then is it federal law?
Well, no, because there's the supremacy clause.
If you sue someone if Scott sued Sanford in federal court, it was diverse, which law would apply?
It's federal law.
No?
The state where the federal court sits.
Yeah.
Oh,
I mean that's Erie, right? Erie haven't decided yet, though. So was it Swift v. Tyson bringing it back, right? There was federal common law at the time, right? So I think Scott was hoping that because you're suing in federal court, the court might apply federal common law rather than the law of the forum, right? Remember, that was the entire premise of Erie, right? When you have an accident, you apply the law of the forum and not some sort of brooding omnipresence in the sky, as Brandeis would call it. Make sense? Okay, very good. So he sued in federal court. Now, it wasn't a federal question. But what was a federal question, right? But, oh, I'm sorry. There was no federal question, so then he sued diversity jurisdiction. Okay, and the reason why there was diversity was because of the diverse citizenship. Now, we know under Article 3 that a citizen of one state can sue a citizen of another state in diversity. But again, that turns on whether you are a citizen. And again, it's not a citizen of the United States. Are you a citizen of that state? So presumably, right, I think at least, Massachusetts could say that this individual is a citizen of our state, right, even if he's white or black. And Pennsylvania can say he's a citizen. But the Missouri Supreme Court just said in opinion that he's not a citizen. Or not really do they say that, though, right? It's sort of an open question. Actually, no, take it back. I don't think the Missouri court would have had to address that issue. So Scott files a suit seeking to determine under Missouri law whether he's emancipated. But a threshold question before you resolve the merits is always jurisdiction, right? You always have to resolve jurisdiction before you can do the merits. And here the jurisdictional question was Dred Scott a citizen of Missouri who could sue Sanford? Right? Today we're so accustomed to, you go to court and you challenge a law on its face as unconstitutional. But you couldn't do that back then, right? There was no 14th Amendment, and there's no federal question jurisdiction. The only way to drag your butt into federal court was through diversity, right? At the most basic level, the conflict in Dred Scott was so simple, right? Let's just say, for example, right, Lindsay, you and I were both citizens of Texas, right? If I walk into federal court and I sue you in diversity, what's going to happen to my lawsuit? Dismiss. Motion dismiss in 5 seconds, right? Would that be of any interest, any lawsuit in that case? No, of course not. So at the most basic level, right, the case about diversity. Chelsea, was Dred Scott a citizen for purposes of Missouri law? No, he wasn't. The entire case could have been dismissed in a sentence. This reminds me of Marbury a bit, right? You could have dumped the entire case in maybe 2 sentences, right? Under Missouri law, he's not a citizen. We looked at state law to decide citizenship. Lack of subject matter jurisdiction, case dismissed. That's it, right? Which is why, I think I said this one year and people didn't interpret it the correct way, but was that part of Dred Scott obviously wrong? I don't, that narrow part about whether he was a citizen under Missouri law, maybe federal common law is different, but under Missouri law, that's an easy question, right? The state court already said, no, you're a slave. You're not a citizen. But why Dred Scott is considered to be so reviled that it's this anti-canonical decision is everything else Tawny said, right? He wrote this long opinion. My God, we have 25 pages in your book. It was like 200 pages, the original one. And in fact, the story goes, it was such a long opinion with so much extraneous stuff that the reporter of the court just didn't put all of it in because there's enough, no more. And this decision was 7-2, right? It wasn't 5-4, it was 7-2. And I think that's reflected by the fact that most of the judges were Southerners, and a lot of them supported slavery. They were okay with this. In fact, if I remember correctly, Tawny's opinion was originally a concurrence, which later became the majority opinion because he had written so much stuff on it. And where does that leave us then? We have 2 dissents, right? Justice Curtis and Justice McLean. Justice Benjamin Robbins Curtis was so disgusted by this decision they actually resigned from the court. He stepped down. He was so mad at Tawny and what he did, he actually stepped down from the court. I can't think of another instance where justice resigns out of spite, that he's so angry at his colleagues. Sure, O'Connor can say that a few times for Scalia, but probably not. But it was a significant decision. One other point. Who were the parties to this case? There was Dred Scott and there was Sanford. The U.S. government was not a party to this case. Right? Usually, if a case involves U.S. government, the court will ask the federal government to file a brief saying, hey, there's some federal issues here. What does the government think? U.S. government was not even asked to file a brief in this case, right? This was just a conflict between two individuals. That will become a big issue later. Okay. All right, so now let's start, okay? Chelsea, let me ask you this question. Tawney could have written a one-sentence opinion. He would have said, under Missouri law, Dred Scott's not a citizen, therefore he's not a citizen, dismiss lack of jurisdiction, right? He didn't do that. No. Instead, Chelsea, how did Justice Tawney go about deciding whether in fact Scott was or was not a citizen?
He used a lot of stuff.
He did use a lot, so that's very, very good statement. Yeah.
He said he used legislation and histories. He used past laws from states.
Was he only talking about Scott, or was he trying to make a bigger picture, bigger point?
A bigger point.
Right, because keep in mind, the Missouri Supreme Court held that Scott was not emancipated, but maybe another court would hold so. He was trying to effectively establish a federal common law for citizenship. That is, the citizenship was not pegged to what any individual state court said. Rather, he was basing it on history. And this is why he goes so far out of his way to say the most racist things you can imagine in a decision of a judge, right? He describes people of African descent as the unfortunate race, right? The unfortunate race. He explains that the Constitution, on its text, doesn't even recognize them, which isn't true. The Constitution's text is somewhat silent on these points. They sort of talk around it. He makes a lot of factual errors also. For example, he claims that at the time of the framing of the Constitution, blacks were not citizens in any state, they couldn't vote, etc., which isn't true. In some states they did have the franchise, in some states they did have various rights. So he makes a lot of, I think, historical errors. He also claims that these individuals couldn't possibly have become citizens, because if they were, they would get the privileges and immunities of citizenship. And he says that's not even possible. Because if that were the case, they have the right to bear arms. We know the slaves can't have guns, right? That's too dangerous. So he sort of makes all these broad, sweeping arguments that are racist. I mean, I don't know any other word I can use to describe it, to explain why these people are not citizens. He explains even if a state pretends to give citizenship to these individuals, it has no effect for purpose of the Constitution. And then he starts crafting a distinction between national citizenship and state citizenship. This is the sort of idea of federal common law, right? That as a matter of federal citizenship, they could never become citizens. Again, the Privileges and Immunities Clause doesn't reference citizens citizens of the United States as citizens in the states. The Diversity Clause in Article 3 doesn't reference U.S. citizens. It's just a citizen of one state and citizen of another state, right? It doesn't reference U.S. citizenship, but Tawney crafts this distinction in order to expand, or actually contract, the people who could ever become part of the polity, part of the governance. Right? Even if a slave was emancipated, or manumitted, as the word was, right? Even if a slave was emancipated, under Tawney's reading, they could never be citizens. Right? Again, so Tawney could have just said in one sentence, Missouri Supreme Court said you're not a citizen, Dred Scott, no jurisdiction. But instead, he tried to create a historical argument that would limit every single African American in the United States such that they could never become a citizen, even if they were emancipated by their owner. Right? He was trying to resolve this issue once and for all to prevent future conflicts from arising. Right? This is the idea of let's just settle everything now and not deal with it again later. Okay? Everyone with me?
I have a question.
Yes, please.
I'm sorry for asking this too, but
Please, don't apologize.
so how would this establish anything if he didn't have jurisdiction?
Oh my goodness, what an excellent question. What about Marbury?
So
Didn't we discuss from Marbury that the court lacks subject matter jurisdiction? So the entire opinion is basically a dictum.
Yeah.
That is more or less what Lincoln argued in part. He didn't make this exact point like you did. But if there's no jurisdiction, why is this decision entitled to any respect? Lincoln made a different argument, which I'll reference briefly here. Lincoln argued that this was not a conflict between the United States government and Scott. It was between Scott and Mr. Sanford, right? The U.S. government wasn't bound to this judgment, has no obligation to respect it. Especially because, Chelsea, you're right, there's no jurisdiction. What the hell are you doing, Tawny? Right? And the lack of jurisdiction makes the second part of the opinion even more nuts. Right? In the second part of the opinion, Tawny decides to resolve a question that was dividing the country. And that concerned the status of the Missouri Compromise and the Free Soil Territories. Right? Tawny actually reached out to this issue. He didn't have to. Right? Usually courts try to avoid resolving constitutional questions. I think that's tattooed on John Roberts' eyelids. Avoid, avoid, avoid. I'm angry. It's Monday, right? I told you I'd be angry today. I'm angry. Always. I'll be more angry on Thursday, and even more angry the next Monday, Tuesday, maybe Wednesday. I'm just warning you now. The Supreme Court's end of the days. They have 20-some decisions left in like 3 or 4 days. I'm not even done with today's decisions. So we up late. But instead of avoiding these issues, Tawny resolves them. And he argues that because of the Due Process Clause of the Fifth Amendment, the Missouri Compromise is unconstitutional, right? That the legislation deprives people of their rights to own as slaves. Okay? Now, Chelsea, I'll give you this question. Do you think the U.S. government, and it's not the reading, but you can take a guess, do you think the U.S. government suddenly said, oh, crap, we have to now allow slavery in our territories? No. In fact, I've looked into this. They continued issuing passports to African Americans living in federal territories as if they were citizens, right? The U.S. government continued doing everything they were doing before with respect to the territories. It's like this decision never happened. Which is why when I teach Prig, I say that Prig had a much more tangible impact on the day-to-day lives of African Americans in the United States than Dred Scott ever did. Dred Scott was, I don't want to say a blip, but as a practical matter, right, it didn't change much. Right? Of course, it changed the life of Dred and Harriet Scott, and I don't want to diminish their humanity. They were denied their day in court, and I don't want to diminish that at all. But the decision didn't go beyond those two people. And their kids as well. It didn't go beyond them. Because the U.S. government continued to keep free soil jurisdiction in the territory. They continued. It's like nothing happened, right? Can you imagine? We always say the Supreme Court makes a ruling and the people ignore it. Well, the Congress basically, they didn't quite ignore it, but it's like, all right, whatever, we're going to keep doing what we're doing before. And again, there were only 2 dissents in Dred Scott, right? Justice McLean and Justice Curtis. And I like those dissents to be there because they sort of preserve for history that not everyone went down Tawny's racist rabbit hole, right? That even at the time there were smart, intelligent lawyers in the court who looked at the world very differently, who saw the evil that was slavery. And I don't use the word evil lightly. I'll use it here. In fact, I did a debate last year at a law school, and the professor said, I enable evil, me. And it's such a, don't water down the word evil, evil, right? This is evil, slavery. Josh, maybe I'm an idiot, but I don't think I'm evil. I don't know. But I like the dissents there because they at least articulate that at the time people were cognizant of how wrong the decision was. It wasn't like, everyone in society thought, oh yeah, this is great. That at least 2 of the members of the court were willing to put their names to a dissent. Okay. So questions about Dred Scott. Just about almost every constitutional issue they reached was wrongly decided and didn't need to be decided. again, dismiss one-word jurisdiction, or just deny review. Just don't even take the case. But Tawney wanted to get it done. So any questions on Dred Scott? All right, so what happened after Dred Scott? The aftermath of Dred Scott, again, as a practical matter, the decision didn't have much of an impact, but it had a very strong public reaction. In fact, Abraham Lincoln, who was really just a lawyer, he didn't have a national profile, but he rose to prominence by attacking the Dred Scott decision. And he made an argument that the Supreme Court, is not supreme, that their decisions cannot decide the Constitution for us. And he made a specific argument that because the case was only between Scott and Sanford, we are not bound by it. In 1858, Lincoln ran for Senate against Stephen Douglas. And they had the famous Lincoln-Douglas debates. You may have heard that expression. That's where it came from, right? It was Abraham Lincoln and Stephen Douglas. And Douglas said that the Supreme Court settles the meaning of the Constitution, and it's final. Right? He wrote, Douglas, I'll read what he wrote. He wrote, "Whoever resists the final decision of the highest judicial tribunal aims a deadly blow to our whole Republican system of government." Douglas said, because it was decided by the court, you're bound. Right? That's it. Lincoln joked, the decision of the court is not like, thus saith the Lord. Right? In other words, Roger Taney is not God. Anthony Kennedy was for a while, but is Lincoln right? Lincoln lost the Senate race in 1858, but in 1860, Lincoln ran for president. And this led to a four-way race. Lincoln won the Electoral College without getting a single Southern vote. Basically, the Southern vote split. At this point, the Union was basically teetering. And before Lincoln's inauguration, several states seceded. And then Lincoln takes the oath of office. And you can imagine the scene, right? It's Roger Taney reading the oath of office to Abraham Lincoln, the man who basically ran on destroying him, right? I'm trying to think of an example. I guess it'd be like Hillary Clinton giving the oath to Donald Trump, right? That's the best I can think of, right? That's going to be something really like, he's like, stop coughing. It'd have to be really bad, or something that I can think of. But, you have Taney, who wrote this decision that defined him, giving the oath of office to Lincoln. And Lincoln tried to put people at ease that things wouldn't be that bad, right? He was trying to tell people, hey, guys, don't worry so much. Southern states, we can live in a nation with slavery and non-slave states, but we have to preserve the Union. This didn't work. Shortly after the inauguration, a number of other states seceded, and they formed a country, or what they called the Confederate States of America. In fact, this group fired on a federal fort in South Carolina, Fort Sumter, and they basically conquered a federal fort. This was, in every regard, an insurrection. Now, we talked about this when we studied Ex parte Merryman, how Lincoln never actually described the war as a war. There was no declaration. This was merely putting down an insurrection. So we already covered that part. I want to talk a little bit more about Taney. His record didn't stand well the test of time. And there's a Scalia opinion you'll read later called Planned Parenthood versus Casey. It's an abortion case, but there's this one line where Scalia describes his portrait of Taney shortly after he wrote Dred Scott. I'll read it to you. He says, "He is all in black, sitting in a shadowed red armchair, left hand resting on a pad of paper, right hand hanging limply, almost lifelessly. He sits facing the viewer and staring straight out. Scalia writes, "There seems to be on his face and his deep-set eyes an expression of profound sadness and disillusionment. Perhaps he always looked that way, even when dwelling upon the happiest of thoughts. But those of us who know how the luster of his great Chief Justiceship came to be eclipsed by Dred Scott cannot help believing that he had that case, its already apparent consequences for the nation, burning on his mind. I expected that 2 years earlier he thought he too was calling the contending sides of national controversy and their divisions." Scalia is basically comparing abortion and slavery, right? That the same way that Roe v. Wade was supposed to end the slavery abortion debate, Dred Scott tried to end the slavery debate. In fact, you often hear a lot, he compared slavery and abortion. That's exactly what they're talking about. It's that exact point, that Roe would end the fight over abortion. And in fact, Casey was supposed to end the fight over abortion. That didn't work either. Maybe the lesson is courts can't resolve social issues of this nature. They shouldn't even try. Scalia wrote, of abortion at least, "We should get out of this area where we have no right to be, and we do neither ourselves nor the country any good by remaining." No one listened to him. Well, now Kennedy's gone. Maybe they will. No, they won't. Okay. All right. Is there any other questions on Tawney and Dred Scott? It's a long decision. There's even other parts where he talks about the states. I mean, the opinion goes on and on and on. It goes on forever. Okay. All right, so we talked about Dred Scott, and I want to walk through now the 13th and 14th Amendments. We don't really do the 15th Amendment, unfortunately. Maybe we should, but maybe voting rights class will have that. All right, so let's start with the 13th Amendment. 13th Amendment was ratified in 1865. I don't think Lincoln made it to the ratification, but he was there when it passed through Congress. If you ever see the movie Lincoln, you ever see the movie? I hated it. I was so excited. It's a movie about the ratification of an amendment. I was so excited, but I didn't like it. It dragged, it was boring, and they took some historical liberties I didn't like. But the 13th Amendment was ratified in 65. And it says, neither slavery nor involuntary servitude, except as a punishment for crimes wherever the party shall be duly convicted, shall exist within the United States. Section 1 of the 13th Amendment did what the Emancipation Proclamation could not do. Right? The Emancipation Proclamation only purported to eradicate slavery in the rebel states. Section 1 did something more than that. It abolished slavery nationwide. And I just want to draw your attention to the phrasing, right? It says neither slavery nor involuntary servitude. Are slavery and involuntary servitude the same thing? Ooh. If they're the same thing, why would they put that redundancy in there? Is slavery something different than involuntary servitude? Is slavery something potentially broader than involuntary servitude? Keep that in mind. We'll be doing cases, I think, for maybe tomorrow or the day after, where some justices suggest that forms of segregation amount to slavery. That slavery was an entirely cohesive institution that pervaded all aspects of our polity. And maybe slavery was something greater. But the 13th Amendment had two sections. I forgot to put Section 2 up there, but it's in your constitutions, right? And Section 2 of the 13th Amendment does something very important, right? It says, sorry, I forgot to put it up there, I'm sorry. It says, Congress shall have power to enforce this article by appropriate legislation. What is that? Congress now has another enumerated power. They are no longer all listed in Section 1, Article 1, Section 8. You now have enumerated power right here in the 13th Amendment. This gave Congress the power to enact laws. What kind of laws? Appropriate legislation. Well, what does that mean? If Congress found there was some problem involving slavery, they could then enact laws to remedy those problems, right? This gave Congress a new enumerated power. And the word appropriate, in many regards, reminds me of the word necessary and proper in Section 8, right? That they can now enact legislation that's necessary and proper to enforce the 13th Amendment. You see, Congress and the Republicans didn't trust the southern states. It's not like, okay, we're going to write on a piece of paper abolishing slavery and then have at it, guys, right? That wasn't going to work. In fact, most of the southern states at this point weren't even part of the Union. They didn't vote for Reconstruction. And other states were only admitted back on the condition they eradicate slavery. So you weren't even like fair votes, right? Basically, the federal government rigged the vote. A lot of people think the Reconstruction Amendments were unconstitutional because the states weren't actually voting in the proper manner. Okay, here and there. So we have this Section 2 of the 13th Amendment to enact legislation. What happens next? In 1866, Congress enacts a statute, a very important statute, which we'll keep coming back to this semester. It was called the Civil Rights Act of 1966. You've already studied the Civil Rights Act of 1964 in Heart of Atlanta and Katzback from McClung. That's the Ollie's barbecue case. But that was 1964. We are 100 years earlier, right? 1866. Okay, why was this law so important? It was the first major legislation Congress used based on its Section 2 powers. By the way, when I say Section 2, I am talking about Section 2 of the 13th Amendment. It's a shorthand, right? When I say Section 2, I mean Section 2 of the 13th Amendment. Section 2 of the 13th Amendment gave Congress its power, or at least they thought it did. Right? First, the Civil Rights Act gave citizenship. It said all persons born in the United States were citizens of the United States. It's basically screw you, Tawny. Right? Tawny said they're not citizens because they're of African descent. No more. Now, if you're born here, you're a citizen. Done. Right? The statute, the Civil Rights Act of 66, was effectively trying to overrule Dred Scott, that they would now be citizens. And as citizens, they have certain rights. The right to make and enforce contracts, to sue, be parties, give evidence, to inherit, purchase, lease, sell, hold, and convey property, and to the full and equal benefit of all laws proceeding for the security of person and property. Right? It said you get these rights because you're citizens. Congress also enacted another law called the Freedmen's Bureau Act. The Freedmen's Bureau Act. This was a creation of an administrative agency to help the freedmen, right? That the newly freed slaves would need some help. And you basically sent federal troops down to the South to prevent these people from being killed, to protect them, give them benefits, land, training, livestock, right? Also gave them the right to bear arms. Now, all these rights I'm listing are the sorts of privileges and immunities that Justice Washington discussed in Corfield v. Coryell, and the sorts of rights that Tawney even referenced in Dred Scott. All right? So these are both statutes that Congress passed. By this point, Andrew Johnson was in office. He was a Southerner. He was from Tennessee. He was also a Democrat. And he was sympathetic to the Southern cause. And know what he did? He vetoed the Civil Rights Act of 66 and the Freedmen's Bureau Act. Now, he probably vetoed them on policy grounds, but he also argued that these statutes were unconstitutional. Johnson contended that the Section 2 powers in the 13th Amendment did not give the Congress the power to enact this law. That this went beyond abolishing slavery, right? In other words, Ending slavery just means ending involuntary servitude. That's it, no more. It did not let you give citizenship to the freedmen. It's not let you give rights to these freedmen. By the way, when I say freedmen, I'm talking about the freed slaves, but that was the word, like freedmen. And they're women too, but it's called them freedmen. I think my first ever all-female class, first time I think. It's good.
We have Freedmen's Town here in Houston, and it's really, really
Yeah. Is it after the freedmen?
It is. So when Juneteenth happened
Yeah,
in
yeah.
Galveston, the freedmen moved up, and it's actually not too far from here. And they took over. They had their own self-sustaining Freedmen's Town, and they laid their own brick streets. And actually, those streets are a huge issue right now here in Houston. They're trying to pave over them.
Oh, I didn't know
So
that.
there is a group led by one of my former archaeological professors who is trying to keep the streets and the printing museum that was opened. They had their own newspaper.
Can you send me a link about this later, please? Thank you. I'd love to read about this. I didn't know this in my hometown.
It's fascinating. The streets are really, really neat.
Please send. I want to go check out later. Thank you so much, Lindsay. Or was it okay? So Johnson vetoed both these bills, and he argued that Congress didn't have the power. In other words, the implied power doesn't reach that far. And I want to just pause here a moment. We've talked a lot about implied powers, right? Did the Fugitive Slave Act, in Prigg, the question was this: did the Fugitive Slave Clause allow the Fugitive Slave Act? And Justice Story said, of course, it's kind of related to slavery, whatever. Here, Johnson takes a very narrow view of implied powers. That the power to abolish slavery doesn't also give Congress the power to give citizenship to the slaves. In other words, the slavery abolition, it means you abolish slavery, done, that's it, you can't go beyond that, not even a step. So when you think about implied powers, it's not always a liberal conservative issue. Sometimes these issues sort of fuzz both ways, right? Like with Prigg. But even then, members of Congress maybe agreed that Johnson may have been right. Right? Maybe Johnson was right. Maybe Congress didn't have the constitutional authority to enact these sort of sweeping civil rights laws. What happened next, people argue about, but we know what they did. Congress approved what became the 14th Amendment to the United States Constitution. And most people agree, not everyone, but most people agree that this provision was designed to remedy the defects of the veto, right? To ensure that the sort of civil rights laws Congress enacted would stay in the books. And again, the 14th Amendment wasn't about the courts. It was about Congress. Today everything's about the courts, right? No. It was Congress supposed to enact civil rights laws to allow people to go to court to sue. That the 14th Amendment wasn't going to be some sort of self-executing provision. Okay, any questions so far? All right, I want to walk through each provision one step at a time. There's a lot of stuff in there. But keep in mind that almost every aspect of Dred Scott is repudiated, right? The 13th Amendment killed slavery. That much is easy to understand. But the 14th Amendment, line by line, is about nullifying the Dred Scott decision. So let's start. 14th Amendment, Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. See what's going on there, right? So first, all persons born. It does not matter what color you are. White, black, male, female, it doesn't matter. If you're a person and you're born here, or maybe you're naturalized here, you're a citizen of the United States and of the state wherein you reside. Here the court, here Congress eliminates the distinctions Tawney drew between national and state citizenship. Right, Tawney said, well, maybe you're a citizen of Boston, of Massachusetts, but you're not a U.S. citizen. Now it makes no difference. If you're a citizen of one state, you're a citizen of the United States. There's no difference. Right? And what's the implication of this? If the freedmen were now citizens of Missouri, they get the Article 4 privileges and immunities. Right? So now a black sailor who docks in a South Carolina port, he is a citizen of his home state, and he cannot be treated differently under the black codes. Right? That's why the provision was so significant. Now, I deliberately skipped over the green part. I'll come back to it now. What does subject to the jurisdiction thereof mean? And this is an issue that never goes away. And has to do with the question of whether people who are born here, but whose parents are perhaps subject to other jurisdictions, can be citizens. And this is a topic of what's called birthright citizenship. This issue just never seems to go away. I'm going to be as narrow as I can. I don't want to editorialize too much. I had a Wall Street Journal editorial on this last year, but we'll be not editorializing here. The most commonly accepted view is that this provision was designed to exclude children of diplomats, right? So let's say you're the children of a diplomat, you're living in an embassy in the United States, and you're born here. Guess what? You're not a birthright citizen, right? You're not subject to our jurisdiction. Generally, diplomats are not subject to our laws. The other position, which is minority, but it does exist, and I'll tell you what it is that the phrase subject to the jurisdiction concerns allegiances and loyalties. And that if your parents have a divided loyalty, that they are themselves not citizens, then that you are not subject to a jurisdiction. The Supreme Court decided a number of cases concerning American Indians. And American Indians basically have countries unto themselves. They are their separate sovereigns. That's why if you go there, they have the casinos and whatever other stuff they do on there, right? So Native Americans are not birthright citizens if they're born in the reservations. They're only citizens by virtue of statute. The court resolved the issue of birthright citizens with respect to Native Americans. They've not cleanly resolved the question of whether you are a citizen if your parents are not citizens. I think they've come close enough for my sake, but they've not perfectly resolved it. And last year, the president made a comment that he wants to sign an executive order ending birthright citizenship. Now, the way I've kept myself sane is I don't respond to everything he says right away. It makes my life so much more blissful. Because in fact, we are a year later, and this executive order doesn't exist. That was an exception. I wrote an editorial in the Wall Street Journal on this exact question about a year ago, and now it's collecting dust. But the way I keep myself sane is by not taking seriously everything the president says. It makes your life so much better because 98% of the crap he says, nothing comes of it. And people just flip the hell out, and he loves it because it's just people flipping out, and then nothing happens. So until I actually see it, I'm going to step back and say, okay, next. But I broke my own policy. I wrote an op-ed like in 2 hours, and I think I was in an Uber to BYU or something when I wrote it. It was a long bus ride, and it's like, we want an op-ed today. I'm like, okay, I'll do it. Okay, that's the birthright citizenship clause. All right, questions on that one? I regret it. I had like a 5 a.m. flight to Utah that day. I was so angry. I was like, oh, okay. Okay. All right, so the next provision is very significant. We already discussed the Article 4 Privileges and Immunities Clause. Okay, Privileges and Immunities Clause. This second clause is the 14th Amendment's Privileges or Immunities Clause. Everyone gets these confused, even the Supreme Court justice gets them confused. And here's how I remember it. Article 4 is and, privileges and immunities. How do you remember that? A comes first letter. 14th Amendment is or, O, right? O comes after A. That's why I remember it every time, right? Privileges or immunities. And then why is it and versus or? It's framed in the negative, right? So if you go back to Article 4, it says, you shall be entitled to all the privileges and immunities of citizens in several states, right? It's both of them. But when you put in the negative, grammatically, or is the correct word. I mean, it's not critical. But it says that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. All right, so take that one step at a time, right? No state shall. Historically, the federal constitution only limited the federal government, right? Barron v. Baltimore. No more. With the beginning of the 14th Amendment, there are now direct limitations on the state's police power. It says you cannot make a law. States cannot make a law. A law that abridges the privileges or immunities of citizens of the United States. So this raises the million-dollar question. What are privileges or immunities of citizens of the United States? Here, I will freely admit there's a debate, not a huge debate, but there's a pretty big debate about what this phrase means. And the reason why we have this debate is because the Supreme Court sort of ignored the issue 200 years ago. In the slaughterhouse cases, which I think you'll read for tomorrow, the Supreme Court read this provision very narrowly, that it only protects certain federal rights. Almost everyone agrees that's wrong. Not everyone, but just about everyone today agrees that's wrong. Now, what's the correct answer? People don't always agree either, but slaughterhouse most people think is wrong, left, right, and center, anyone else. But we looked to a couple sources of guidance, at least Randy and I. This is, again, Randy and I agree on this one almost entirely, but we're not the only ones that is thinking about these issues. So one source of authority of what are the privileges or immunities is that we look to actually the first 8 amendments, what we now call the Bill of Rights. Recall that Tawney and Dred Scott referenced the fact that the right to bear arms and the right to free speech were privileges and immunities. Those are, of course, the First and Second Amendments. And in several important speeches in Congress, for example, Senator Jacob Howard of Michigan referenced the provisions of the Bill of Rights, the first 8 amendments, as among the privileges and immunities. What this would mean is that states can no longer violate the freedom of speech. They cannot violate the right to bear arms. They cannot conduct unreasonable searches and seizures. They could not, violate the right to petition, for example, of grievances. Query, does that involve the Establishment Clause? Because we discussed the Establishment Clause, I think, is best read to limit the federal government's interference with state churches. But that's in there. So the easiest one, I think what most people agree, is that the Privileges and Immunities Clause overruled Barron, that now the Bill of Rights, first 8 amendments, limited the state's police power. That part's easy. I think almost everyone agrees with that much. The next part gets a little more dicey, right? Are the privileges or immunities in the 14th Amendment the same rights that Justice Bushrod Washington discussed in Corfield versus Coriell, right? The right of property, the right of contract, these sorts of things. Contract wasn't in, I'm sorry, but right of property was. We have some evidence. Senator Jacob Howard, for example, referenced Corfield v. Coriell and said that these civil rights, he called them civil rights, from Corfield are privileges and immunities. So we have the Bill of Rights, we have Corfield v. Coriell, and what else? Well, here's the part that I think most people will start going off reservation on. Randy and I, at least, look to the Civil Rights Act of '66 as another source of guidance about the meaning of privileges and immunities. This statute listed various fundamental rights: the right to make and enforce contracts, and the right to convey real and personal property. We know that the 14th Amendment was designed to protect the rights specified in the Civil Rights Act being repealed in the future. If this premise is correct, then I think it's a good guess that the privileges and immunities were those listed in the Civil Rights Act, right? That this Constitution prevented future Congresses from repealing these laws. Now, not everyone agrees here. One of Randy's best friends and nemesis, a person named Kurt Lash, who's a dear friend of mine, he argues that Randy's totally off base. I'm like Switzerland, it's not my problem. But there are differences of opinions on this issue. Randy and Kurt are actually very good friends now, but they used to have fight, but now they're good. I feel like Newman and Seinfeld. I won't say who's who. Okay. We'll focus on the PRI clause, I'll call it that for short, tomorrow when we do Slaughterhouse and Bradwell and Crookshank. Okay, so any questions on PRI? All right, the next provision we'll probably spend 8 or 9 classes on, which is the Due Process Clause. We already discussed the Fifth Amendment, which says that Congress and the federal government cannot deprive a person of life, liberty, or property without due process of law. The 14th Amendment adds a new one, that the states, no state shall deprive a person of life, liberty, or property without due process of law. States are not subject to the same restriction, right? They couldn't lock up a slave without any process, that they give them any sorts of procedures that were needed. Additionally, the 14th Amendment's due process clause would play an important role. After the Slaughterhouse case, all right, Slaughterhouse narrowly read privileges and immunities, courts began to consider the due process clause. So under modern doctrine, a lot of the court's cases that protect rights under the due process clause are, as an original matter, better viewed as rights in the privileges or immunities clause. We'll do cases discussing this, but generally, the court's gotten to more or less the right place in some regards by using PRI. They've done a lot of, by using due process. They've done a lot of other stuff that's wrong, but at least the incorporation doctrine, which is today is all the rights in the Bill of Rights are extended to the states, at least that much is consistent with the privileges or immunities clause's original meaning. So at least that much is good. Okay, any question on the due process clause? Okay. The next provision is the Equal Protection Clause. It says that the state shall not deny to any person within its jurisdiction the equal protection of the law. This provision meant that the states had to enforce the law equally. Protection meant the enforcement of the law. That is, the states have a duty to enforce the rights of all people, white and black, male and female. And they also have a duty to protect them from people depriving them of their rights, namely the privileges and immunities. So if some state government actor, or I think even a private actor, is depriving someone of their rights, the state has a duty to intervene. The analogy is the Civil Rights Act of '66, which said that citizens were entitled to the full and equal benefit of all the laws and proceedings for the security of person and property. Right? The state to protect your rights. And in many regards, if you want to go really old school, government was created to protect people. That's why people left the state of nature and entered civil society for protection of their rights. And that's the bedrock principle that at least Randy and I subscribe to. Go back to the state of nature. It would be very dangerous. I don't have Uber there. I don't know what I would do. All right, any questions on equal protection? All right, let's jump ahead. Section 2, 3, and 4 of the 14th Amendment, there's good stuff in there. I did the first day of class. But for our purposes, we'll talk about Section 5. When I say Section 5, I am referring to Section 5 of the 14th Amendment. We already discussed Section 5 briefly. When we did Heart of Atlanta, we discussed Section 5, whether Congress can enact the Civil Rights Law of '64, this provision. When we did RFRA, remember Bernie v. Flores? And whether Congress can waive its state sovereign immunity pursuant to Section 5. Section 5 was the enforcement provision. It gave Congress a new power to ensure that people were complying with Section 1. So for example, if a state was depriving its citizens of life, liberty, or property without due process of law, Congress could intervene and enact a law. That law, for example, could allow the state to be sued. You probably heard of 42 U.S.C. 1983, right? That was actually enacted under the 13th Amendment. It's called the Ku Klux Klan Act, right? That if a state official deprives you of your rights, you can go to court and sue them for damages in federal court. Generally, you can't sue a state in federal court, except when Congress waives that immunity. So the Section 5 was designed to be this power that would ensure that Congress could intervene if people's rights were being deprived. Okay. Questions in Section 5? All right, well, things started off very promisingly. With the 13th Amendment was ratified, abolishing slavery. And then the 14th Amendment was ratified, and then a couple years later, the 15th Amendment was ratified. These three amendments were ratified in the span, I think, about 5 years. And they were, at least on paper, designed to greatly expand the rights of the freedmen. But soon enough, the southern states began to be readmitted to the Union. And support for these sorts of civil rights laws began to fade. As well, nationwide, the popularity of Reconstruction plummeted. And in the South, resistance started to arise to the idea that the federal government was imposing upon them this new culture. Terrorist groups like the Ku Klux Klan began to form in the South, and their goal was to especially terrorize the freedmen. States began to enact various black codes, what became known as Jim Crow laws, to enforce segregation. There were limitations on voting, poll taxes, grandfather clauses, these other measures to basically deprive the freedmen of their rights. You read about an incident in class for tomorrow, the Colfax Massacre, which was this wholesale slaughter of freedmen living in Louisiana. And it was a genocide, it was a slaughter. Congress was not willing to step up for the rights of the freedmen, and increasingly the executive branch was less and less willing to fight for the Reconstruction. They found it wasn't as popular as it once was. So they may ask, Josh, what about the courts? The courts, for the most part, were resistant to using the Reconstruction Amendments to challenge state laws. Now, today we think, of course, the courts are involved. Of course, the courts will step in. But at the time, the federal courts had almost no business over state laws. Right? State laws were almost immune from federal review. Every now and then you'd have like McCulloch v. Maryland or something, but most constitutional issues arose from federal laws, not state laws. Right? So we have then a series of decisions between 1873 and 1896, about 23 years. And these decisions systematically read the 14th Amendment in a very narrow fashion. And they did this because they did not want to alter the relationship between the states and the federal government. In other words, they wanted to try to maintain the sort of role the Supreme Court had before Reconstruction. Okay? And indeed, this is actually Kurt Lash, mentioned his name a minute ago. He has this theory, which I find intriguing, that there was a fear that the court would actually declare the 14th Amendment unconstitutional. What? That the court would say that this was not properly ratified, that the states were basically coerced to ratifying it, that the states weren't actually constituted properly. So therefore, the amendment itself is unconstitutional. And if the amendment's unconstitutional, the entire edifice of Reconstruction was over. So as bad as Slaughterhouse was, Kurt suggests, it could have been worse. And they could have said, sorry, 14th Amendment's unconstitutional. Ratify it again properly. Nope, not going to happen. All right, so in the next few classes, we'll be discussing several key cases. So first, tomorrow, we'll be doing the Privileges or Immunities Clause. And we have three decisions. We have the Slaughterhouse cases, 1873. We have Bradwell v. Illinois, 1873. And United States against Cruikshank, 1875. The first two of these decisions held that the 14th Amendment did not protect the right of contract. Right? That was a right listed in the Civil Rights Act of '66. The court held that no, the Privileges or Immunities Clause did only refer to federal rights, not the right of contract. Cruikshank involved whether the PRI clause protects the right to bear arms and the right to associate freely. The Supreme Court said nope, no incorporation, right? None of the provisions of the Bill of Rights extend to the states. Barron is still good law, right? That The 14th Amendment did nothing to change Barron. So as a result, the Bill of Rights would not be extended to states till basically the early 20th century. So that was the first round of cases from 73 to 75. In 1875, Congress enacts the Civil Rights Act, a very important law. And this law prohibits segregation in public accommodations, right? It actually made it a felony, a federal crime, to exclude someone from business based on their race. Very forward thinking, right? We wouldn't get a law like that until the 1960s. In 1883, the Supreme Court decided the civil rights cases. And the court held that the Civil Rights Act was unconstitutional. The court held that Congress cannot limit private businesses because there's no state action. That the Congress only restricts state segregation, not private segregation. At this point, Congress's last-ditch effort to try to eradicate Jim Crow failed because now businesses get segregated without any repercussions. I'll pause to note, no one suggested at the time that Congress could regulate businesses through the Commerce Clause. Right, there was no hint that the Commerce and Necessary and Proper Clauses could be used to eradicate segregation. This is why when we get to Heart of Atlanta and Katzenbach and McClung, the court goes right to the Commerce Clause because civil rights cases kill Section 5. Remember, Justice Douglas was the only one willing to look to the Section 5 in Heart of Atlanta. Everyone with me? And then we have the case that goes the furthest, which is Plessy versus Ferguson. It's a name that most people know that name before they even get to law school. So again, civil rights cases said that Congress cannot ban segregation in private businesses. Plessy said that the states themselves were allowed to segregate in government facilities, like train cars, for example, so long as the facilities were separate but equal. That is, you had one white car and you had one black car on the train. Taken together, these decisions enable the rise of Jim Crow. This regime of state-sanctioned slavery, racial subordination and discrimination was enacted throughout the southern states. And this legal regime was reinforced by organized private violence against African Americans as well as white people who stood by their side. Even though we had a 13th and 14th Amendments, law enforcement, police, state actors, right, refused to respect the civil rights of some of their people. These decisions also inhibited the fight against public and private racial discrimination throughout the United States. The promise of the 14th Amendment was not fulfilled, yet because the text, right, the Constitution enshrined the promise in its text, that promise later could be kept. Okay. Any questions? Anything in your minds? No? All right, I will see you all tomorrow night. Thank you so much.